everybody is expected to complete an attendance register every day, Lorraine. You can only be absent with my permission. If you are absent without cause, consider yourself to have been disqualified from this program. You should attend every session, every activity, and benefit from what is being offered here. So really, that's very important. The faculty, these are the people who are going to do the training. We have engaged 2 advocates, both of them ladies, very senior people who do litigation every day in the superior courts. For the first training, I had used advocates Natasha Basingwade and S.E. Chase, who, as you may know, has since become a senior counsel, to do the training. Advocate Chase, for some reason, has become unavailable. She's doing something during this period. So we have replaced her with a lady called Advocate van der Westhuizen. I don't know her first name. Charmaine is her. She will be the replacement for Advocate Chase. Now, tomorrow she will start with the actions part of the training. And once she's done with that, Advocate Basingwade will come in with motion practice applications. An exam will be done, an exam or exams, depending on how you see it. My idea is at the end of every installment to have an exam, but I'm still thinking about it. So if you finish actions, we give you reading time, do actions, and exam, emotions, the same. That's really the idea we have broadly at the moment. It may or may not be an open book exam, depending on how you see it, but you will be allowed access to your statutes, principally the High Court Act, the rules of the High Court, the practice directions made under the High Court Act, and the registrar's notes also made under the rules of the High Court. I will still discuss this with the people who set the exams, to what extent they want to allow other material to be available, but that will be the basics. I know Lorraine made some material available to you, and I assume those are the statutes, the rules, the practice directives, and the registrar's notes. All those you have. The High Court Act, I hope it's the Judas Start version. It should not be the one from the books, the statute book, because they are not annotated. So you must make sure you access the Judas Start version. I'm not sure what you have, but we can check. But the Judas Start version is the one that will have everything. Because you go to the brown books that we know, there are provisions which should be there but are not there. You are only made reference to a legislation that was passed later on to substitute something. So Judas Start version is what you must have. The aspirant judges training program. I must start off by what it is not. Going through the program does not guarantee you to become a judge. I'll start there. So please, let's not have any illusion about it. It does not guarantee you to become a judge. It doesn't guarantee you to become an acting judge. It doesn't. What it is that it is principally and primarily focused on magistrates, although as you can see we include here and there other court officials, magistrates who qualify for appointment as judges or can be considered for appointment as judges. And for that purpose, I want you to look at both the High Court Act and the Judicial Service Commission Act. In the interest of time, I'm not going to refer too much to sections and things. I want you to also do some of the work yourself. So if you look at the High Court Act, requirements, qualifications as a judge, and the Judicial Service Commission Act, you'll see how the law was changed to make a greater number of people qualified to be appointed as judges. The purpose of the program is to introduce candidates to the High Court's jurisdiction. its organization, rules, procedures in respect of civil cases. Now, why the focus on civil? The way the magistracy is trained and performs its task has almost exclusively bias on criminal law and procedure. Next to no civil cases are heard in the magistrates' courts, except perhaps for maintenance inquiries and limited debt enforcement procedures such as garnishee orders and emolument attachment orders. And I confirm this on the visits that the Chief Justice and I undertook to the regions. Everywhere I went, I tried to find out from the stations how much civil work they do. And I was shocked. Almost no civil work takes place in the magistrates' courts. Now, that disadvantages magistrates in that it hamstrings their potential for elevation to the High Court. Now, if you exclusively do only criminal work, it's very difficult for you to be considered for appointment to the High Court. Now, in the past, what we did to address the problem is that we brought in magistrates and put them in the criminal stream, to which I will make reference soon. But that's too limiting. People must have the opportunity, if they want, to do other areas of the law, and therefore the program is important in that respect. Now, the aspirant judges training program's focus is exclusively on the High Court's civil jurisdiction. We do not cover criminal procedure and law. We might in future, actually the PS and I are in the process of discussing it, how to do that. Now, even if the opportunity to act never comes, you still put the knowledge that you'll get here to good use. That's the important thing about it. Now, it's important for the following reasons. Besides the increased civil jurisdiction, which is coming to the magistrates' courts, we are busy working on a bill to increase civil jurisdiction in the magistrates' courts. We are also working on another bill to introduce divorce jurisdiction in the regional courts. So that's important, and for that you will need to have knowledge of civil procedure. So I urge you, even after you have left this program, to continue to read up on your civil procedure and make it a habit to read the major judgments in the High Court. The High Court has too many judgments, so it will be unrealistic to expect you to read all of them. If you can, fine. I hope it doesn't surprise you. I try to read all of them myself. But you have other things to do, so it may be difficult. But read the major judgments that are coming out from the High Court. And for heaven's sake, read all the Supreme Court judgments. Supreme Court judgments, you must read each and every one of the Supreme Court judgments, both criminal and civil. Make that habit, because that's the only way that you really get a very good appreciation of what the law is in the country and the current jurisprudence. Now, what is the civil jurisdiction of the High Court? The first point to be made is that the High Court is a court of unlimited general jurisdiction over all causes. Look at Article 80, sub 2. This is what it tells you. The High Court shall have original jurisdiction to hear and adjudicate upon all civil disputes and criminal prosecutions, including cases which involve the interpretation, implementation, and upholding of this Constitution and the fundamental rights and freedoms guaranteed thereunder. The High Court shall also have jurisdiction to hear and adjudicate upon appeals from lower courts. So a court of unlimited general jurisdiction. It is the only court in this country which has that jurisdiction. Not even the Supreme Court has that jurisdiction. Unlimited in the sense that the Magistrates' Court doesn't have that jurisdiction. The Magistrates' Court has jurisdiction only in respect of those matters. It is given jurisdiction by a statute. So, as we always say, the writ of the High Court runs through the whole country. That's the expression you must always remember. Now, If no other statute makes special provision for which court shall have jurisdiction, the High Court automatically has jurisdiction. In other words, there is nothing that is not within the jurisdiction of the High Court unless it is specifically excluded by statute. But the ouster, or in other words, the exclusion of the High Court's jurisdiction is not lightly presumed. In that respect, I want you to read two judgments, references to which I'll provide through Lorraine. One is the Peter Naholo judgment, and the other one, Onesmus versus the Social Security Commission judgments. Very important, where you are going to see what the courts have said about the extent to which you can oust the jurisdiction of the High Court and what the limits are. Particularly the Onesmus judgment is very, very instructive. Now, there are some areas where certain types of dispute have been excluded from the High Court's original jurisdiction. For example, labor disputes under the Labor Act of 1992, and I won't say a lot about that because Judge Parker is coming to speak to you about that. But that is again only in very limited respects. Certain disputes are still in the court's purview. For example, the High Court remains the court of review and an appeal court in relation to appeal matters. But if you have an unfair dismissal complaint in this country, you can't come running to the High Court. The Labor Act has created a special procedure for how you deal with that, mediation and arbitration. And in a number of cases which Judge Parker will speak to you about, we have refused to hear matters which are reserved for the jurisdiction of the mediation arbitration process. But again, that is possible only because the statute says so. And appeals and reviews from those proceedings lie to the High Court. So the High Court is, in another sense, also your labor court. The Labor Court is a division of the High Court. That's what the Labor Act actually says. The other provision is the Electoral Act. Again, I want you to take the trouble to read it up yourself. In the notes that I will provide after I've edited my notes, I'll give you the references to all the statutes. Now, the Electoral Act creates a three-tiered adjudication process. The first one is the Electoral Tribunal, which are the magistrate courts, to hear certain types of complaints. And then you have the Electoral Court, which is the High Court. So the Electoral Court is also a division of the High Court. And its function will be twofold. One, to hear appeals and reviews from the Electoral Tribunal, and there are limited extent to which it is responsible for certain other disputes in the High Court. So I'm mentioning these things because you must be aware of what are the sort of things you'll be expected to do when you become a High Court judge. When you hear that's a High Court, what does it mean? So it means all these things that I'm telling you about. The third layer is the Supreme Court. Now, disputes relating to the results of presidential elections have been reserved exclusively for the Supreme Court. Only the Supreme Court can hear a complaint relating to irregularities or wanting to set aside a presidential election. Only the Supreme Court can hear that. Whereas the High Court hears other forms of election complaints. Very, very important to remember. And that is one of the few instances in which the Supreme Court is made a court of original jurisdiction. So in respect of election disputes involving the presidential elections, the Supreme Court is the one and only court of original jurisdiction. The High Court is also a court of admiralty. Admiralty are your disputes relating to matters that happen on seas. People want to attach vessels, shipping vessels, in order to satisfy debts. Salvage of vessels and those things, a very important jurisdiction of the High Court. It's still governed by very archaic laws, some of it going back to 1885, thereabouts, laws made by Queen Victoria that governs the jurisdiction of the High Court in Admiralty matters. So take an interest in that. I don't really intend to go into much of that. I just want you to be aware that that's an important jurisdiction of the High Court. Now, having said that, the main diet of the High Court's jurisdiction, in addition to the matters that I've just referred to, apart of course from its criminal jurisdiction, which we are not dealing with in this program, is constitutional law review. If somebody wants to challenge an act of parliament, somebody wants to challenge a regulation, somebody wants to challenge a particular conduct, and remember, constitutional challenge, most people confuse this, is not confined to challenging provisions of a statute. Even a decision that the president takes or a minister takes can be challenged on constitutional grounds. So constitutional law review is one of the most important functions that the High Court has. The other is administrative law review, which is, and the extent to which somebody wants to challenge a particular decision, say immigration official has taken a decision, the passport, you are refused to travel, somebody has refused to issue a passport, that falls under our administrative law review function. And when Advocate Basingwaite comes to speak to you, she will speak to you about that administrative law review under the rules. The other is divorce. It's the court, at the moment, only court that grants divorces. Now, when it comes to divorce, in this program, we are not going to cover a lot about the substantive law of divorce for constraints of time, but I have made a commitment to Mrs. Klassen, your Deputy Chief Magistrate for Training, the Chairman of the Commission, and Mrs. Alionga, that at the right time, before the law is changed to introduce divorce jurisdiction for the regional court, I will design a special program to train the magistrates on divorce law so that you are ready for that function when it comes. The other is delict. Delict is the other sort of case that comes before the High Court. Involved in a car accident, you think the other driver was negligent, that's the court you come to. Although, of course, you can come to the magistrates also. As you know, what divides us is monetary jurisdiction and where the person finds themselves. But the High Court doesn't have any monetary jurisdiction. It's not linked to where the president resides or person works or resides. The High Court's jurisdiction is not limited in that sense, whereas the magistrate's court jurisdiction is limited. So if it falls within a certain, below a certain threshold, it can go to the magistrate's court. Above that, it comes to the High Court, although for the reasons that I've already mentioned, all this litigation in delictual matters at the moment takes place only in the High Court. Contract, commercial disputes, wills and succession, people fighting over who should inherit whose property, those are the sort of things that are heard in the High Court. And the sort of things that you read about every day almost in the newspapers, urgent relief. Somebody wants on an urgent basis to stop somebody from doing something, they come to the High Court to seek urgent relief. And again, in the motions part of the program, that will be dealt with. As the other thing, of course, is appeals from magistrates' courts that we do. Now, I'll briefly speak about the organization of the court. The head of jurisdiction, as you, I'm sure, know, is the judge president, deputized by the deputy judge president. Because of the enormity of the task that I carry at the moment, also assisting the Chief Justice as his deputy, both in terms of running the office that has been created, in my responsibilities as the Supreme Court, because I also sit on that court, I have effectively delegated the running of the civil stream, the civil side of the court to the Deputy Judge President, who is the one who assigns duties to the judges on a day-to-day basis on my behalf, subject, of course, to my supervision. I want you to look at Article 80. No, sub 2. That's not the right one. Is that one? Article 80, sub 2. It's not. It's the wrong one that I cited to you. Anyway, I'll get back to you. It's probably 79-1. So look at Article 79.1 about the composition of the Supreme Court and the role that the Deputy Chief Justice plays there, and rule at Article 80 sub 1 for the leadership of the High Court, the Judge President deputized by the Deputy Judge President. Now, speaking about the organization of the court, I have divided the work of the court in two streams, what we call the civil stream and the criminal stream. I'll soon be talking to you about case management and how that impacted the work of the court. And the division of the court in two streams was really motivated by that. We realized that when we created a system of judicial case management, it was extremely difficult. It almost became impossible for a judge to function in both the civil stream and the criminal stream. And you'll see very soon when I come to speak about that, why that is. So I grouped the judges into two groups, civil stream and a criminal stream. Now the judges in the criminal stream do exclusively criminal work. Criminal appeals, hearing criminal trials, the automatic reviews that comes from the magistrates' courts, and bail appeals and bail applications and that sort of thing. Whereas there's the active case management of civil cases, which I'll talk about, is the responsibility of the judges in the civil stream. So remember that when you come to the High Court, you will be expected to work in one of the streams. The civil stream is in turn subdivided in two parts. And here I'm excluding the Northern Local Division, which has only one judge, and therefore the judge in that in the civil stream is really doing all the things appertaining to that substream. So the civil stream subdivided into what we call motion and action stream. In this program, you'll be talking about motion cases and action cases. So we have a subdivision. In the past, and maybe for the last 2 years or so, I had a judges who are in the stream stay in that stream for that long, about 2 years. But I've decided to change that for reasons that's not necessary to explain here. So every 6 months, we are going to rotate them. So you will be 6 months in one substream, motions, and after 6 months, you move on to the action stream. Another important initiative that you should be aware of when you come to work at the High Court is that we have e-justice, electronic filing. If you have the time, during breaks, ask Ms. Magomele about it. She will explain to you more. She works with the judges on e-justice. What it means is that I can sit anywhere in the world today and file a case in the High Court without coming to the court. I can file a case, I can prosecute a case up to a certain stage, of course, until the court schedules a hearing. Then I'm expected to come to court, but I can sit anywhere in the world while sitting on the beach, having a nice time. With my laptop, I can file a case in the High Court. Another important initiative that we introduced at the High Court, which the registrar will come and speak to you more about. And you will be expected to operate when you come to the High Court. The other one is mediation in civil matters. For that, you must look at rules 38 and 39 of the High Court rules. That sets out the procedure and the processes for mediation. And together with that, you must read the relevant practice direction, which governs mediation. What it means is that about 70, perhaps plus, cases in this civil stream, except motions, 70 to 80% of those cases will at some stage go before a mediator, before it goes to trial. And what it means is that a court-appointed mediator sits with the parties to try and resolve the dispute between the two parties. Only if that fails does the case go to court. So mediation is a very, very important initiative that was introduced, and which, as managing judges, you should be aware of how it functions, and the modalities of that will be spoken to you later on. Now, the High Court has two divisions: Windhoek, the main division, the Northern Local Division, where Mrs. Wakatama comes from. As I said there, I have only 3 judges, 2 doing the criminal work of the court, 1 doing the civil work. Now, in terms of Section 2, capital A of the High Court Act, the High Court consists of the main division in Windhoek and local divisions established by the President by proclamation. The President has since proclaimed the Northern Local Division of the High Court, the main division and the Northern Local Division, and the Judge President has declared Oshakati as the seat of the Northern Local Division and determined the local limits of its jurisdiction to be the District Division Oshakati, consisting of the districts set out in column 2 of Schedule to Government Notice 22 of 17 February 1994. So the Northern Local Division deals with the areas that are defined as District Division Oshakati. That's the division where Mrs. Wakatama comes from. Now, the local division has what we call concurrent jurisdiction with the main division. What does that mean? The consequence of the concurrence of jurisdiction is that the main division, that is Windhoek, is competent to exercise jurisdiction over any matter falling under the local division's jurisdiction, but not the other way around. So, if a dispute has arisen in Windhoek, the Northern Local Division does not have jurisdiction unless it is transferred to that division in a way that I will describe to you presently. So any dispute, if you have a dispute that has occurred in Oshakati, you are free to come to Windhoek and file your case. But yeah, and this, the reason for that is this court has concurrent jurisdiction of the local division. Now, how does transferring of cases work? If you look at Section 5 of the High Court Act, it makes it possible for a matter to be transferred from one division to another. So look at that section, and there are relevant rules around it. Look at the rules of the High Court in how that is done. Usually, the practice that has developed is that the parties make a request to the managing judge to say, look, we think our dispute will be best dealt with either in Windhoek or in Oshakati, depending on where you are, and then the judge will make an order to that effect, transferring the case, either from this division to the Northern Local Division and vice versa. Now, I want to deal briefly with other formalistic issues, how the High Court as a court is constituted. I want you to look at Section 10, sub 1 to 3 of the High Court Act, which deals with the constitution of the court. When the High Court sits as a court of first instance to hear a civil matter, it is constituted by a single judge. But the Judge President may at any time direct a matter to be heard by a full court. A full court will mean 2 judges or 3 judges. And a single judge, if you are sitting as a judge, and this happens very often, a single judge sitting hearing a case says, look, there are very complex issues involved here. Maybe they are constitutional. Maybe they are of important public law matter. They come to me and they say, JB, I think you must constitute a full court here. I think it's best if 2 judges or 3 make a request that that matter be heard by a full court, and that can be done. So ordinarily, one judge, but in certain circumstances, 2 judges or more can sit on a particular case. A settled practice has developed since independence that if a provision of either the common law or statute is being challenged as being unconstitutional, the court is constituted of 2 or 3 judges. Although it is not at all unlawful for one judge to decide the constitutional matter, it is good practice if somebody has to go and decide whether a particular law is constitutional or not, that you have more than one judge, to allow the judges really to debate the issues and to come to a more informed decision. So that you understand. Yes, Ms. Wagatama?
I'm sorry to take you back a little. When Judge President is consulted to consider a full court in the civil matters in the High Court, are we making room for the 2 to 3 judges for any of them to dissent, or are they sitting as a full court but directed within a certain course? Is there room for dissent?
Oh, yes. Yes. It's your duty to dissent if you don't agree. When I come to speak about judgment writing, I'll speak more about that. But since you raised it at this point, I was going to speak to you about it more later on when I speak on judgment writing. One of the fundamental principles of our constitutional democracy is the independence of the judiciary, both individually as a judge and as an institution. Not even the judge president can tell you how to decide the case. It's one of the first things. When somebody is sworn in at the High Court, I have a lecture of about 30 minutes telling them how to be independent, not to be influenced by anybody. And that includes, if you disagree, to say so. If you disagree, even with the judge president, you sit on the same court, and you think his view of the law is wrong, you have a duty. You have a duty to dissent from what the other judge says. The other circumstances is that even where a matter commences before a single judge, I can issue a directive to immediately stop the hearing of the case and say I want it before 2 judges. That is a power that I also have. And not only that, even while you are sitting and maybe you have already started hearing the case, and you feel, look, I think this matter must be heard by 2 judges, you adjourn your court, you come to the judge president and say, Judge President, I feel you must appoint 2 or more judges. In some cases, I have disagreed and said, go back and hear it alone. But once the judge has normally applied his or her mind, I give effect to that because he or she had probably thought about it carefully. Civil appeals are ordinarily heard by a single judge, so if there is an appeal from the magistrate's court, I would normally assign 1 judge to hear it. Unless I want an authoritative decision on a question on which there are divergent judicial pronouncements. So there are certain cases where you see there are 2 or 3 different opinions expressed in judgments about what the law should be. So if a civil appeal comes from the magistrate's court, I'll normally put a larger, bigger bench of judges in order to decide the question so that we have an authoritative judgment, because, as I'll speak during judgment writing, a precedent established by a bigger number of judges has a bigger weight than one established by 1 judge. The quorum of the court is governed by Section 14, Sub 1 of the High Court Act. And that comes now to the question which Mrs. Wagatama asked. And unless a contrary provision is made by a statute, the judgment of the majority of the judges of the full court shall be the judgment of the court. So if it's 3 of us, 1 of us disagree, the judgment of the 2 stands. The trouble is if there are 2 judges and you don't agree. What happens in those circumstances is that the judges will come to the judge president and say, We have heard the case. We cannot agree on what the outcome should be. I have one view, my colleague has another view, and then the judge president then assigns a third judge to sit with the judges to determine the matter. And where the judgments of the majority of the full court are not in agreement, so if there is a complete stalemate, each and everybody has a different view of what it should be, the hearing shall be adjourned and to commence de novo before a new judge constituted in such matters as the judge president shall determine. Now, how do we deliver judgments? All final judgments must be pronounced by word of mouth of the judge or one of the judges on behalf of the full court. So every judgment of the court, somebody must go into court and announce the judgment. You don't always have to go, all three of you or two of you, if you are more than one. It's enough if one person does it. A judgment must be pronounced publicly, in daytime, and in the presence of the parties, after notice to the parties has been given. Very, very important, because justice is a public affair. We should not give judgments secretly. The public must know what judgments have been given, and that this must be done in public. It is acceptable practice for a judgment prepared by one judge to be delivered on his or her behalf by a colleague, on condition that the parties are informed of the date, and it is done in public and in daytime. So I finished writing my judgment. I am going on leave on Monday. The judgment is to be delivered on Monday. I will arrange with a colleague to come and hand it down. That's what we call hand it down on my behalf. In the High Court, we don't always read judgments. In criminal matters, we do, especially when it comes to determining the merits of the matter. You have to read the full judgment in open court. In civil cases, it is not strictly that way. Yes?
I just want to ask, as per that point, especially in instances where the court is hearing an urgent application, and it is not in the ordinary business of the court, it's in the evening when the court has got to announce the order of the application, urgent application.
So you can announce it in the evening. You are addressing the daytime issue. Yes, you can announce it in the evening. Yes, that's an exception. Because when you come on an urgent basis, you have really suspended all the normal rules of the court. So thank you very much for that. You should be able to, at midnight, if that's the decision you have taken, announce the judgment. You know, there are instances in which an urgent application can be heard even at the house of the judge. It can be heard away from the court. But again, the urgent obligation is of the nature that it suspends all the normal rules and processes of the court. So you come to my house, I hear you in my pajamas, in my study, and you address me. After that, I announce the order of the court. That's permissible. That's permissible because of the nature of the proceedings.
May I just take you back, please? So are you saying that for civil matters, you don't need to read your reasons, the whole couple, you just need to read the order?
Yes.
Criminal, it's different.
Yes, sorry, I almost skipped that one, yes. In civil matters, really, it's very exceptional if a judge reads the full judgment. We just come in, we say, I now announce the order of the court. The judgment is handed down herewith, and the order of the court is such and such, and I hand it down. That's a normal practice. But in criminal cases, we always read the full judgment. Yes. I want to briefly deal with a few accountability measures that we have introduced at the High Court. The first one is the disposal benchmark. I want you to look at Practice Direction 62. That's very, very important. I have determined that each type of case must be finished within a certain time period. That's really your disposal benchmark. A divorce case I expect to be finished within 6-8 months. I can't remember it is now, but practice direction 62 will tell you. The other is deadlines for judgments. We came from a history where the courts, the superior courts, really didn't do us a great deal of service by delaying judgments for a long time. So what has since happened is that the Judicial Service Commission has introduced guidelines agreed with the heads of court. So I had to prepare in respect of the High Court guidelines, which I think are reasonable, which I have discussed with the judges. Chief Justice, the same for the Supreme Court. So there are guidelines. I know as a judge, if I hear an interlocutory matter, if I hear a divorce case, if I hear a constitutional case, how much time do I have to deliver judgment? Very important, because I enforce them. In the past, not very strictly, but lately, very strictly. So it's one important thing to bear in mind. Now, when it comes to judgments and the time guidelines that are given there, we make a distinction between interlocutories and the merits. So if somebody comes with an application to amend, or an application seeking discovery, that's an interlocutory application, I'm expected to deliver judgment in a shorter period of time, say 2 weeks. What is the guideline these days, Mogomele? 2 or 3 weeks, interlocutories. The idea also is that if you take a year to write a judgment in the interlocutory matter, it stalls the case. So you need to give judgment as quickly as possible in interlocutory matter so that the matter can proceed. I want you to look at Annex 10 to the practice direction. That gives you a complete set of the guidelines there. Now, that's the introductory part about the organization of the court. The next thing I want to do is to talk about judicial case management. But I think let's take a 10-minute health break, and I'll come back to speak on judicial case management, because that is going to be a more involved and testing area, and I intend to finish by 10:30. So if we come back, say quarter to 10.